All right, so we are live and appreciate everybody's patience as we get things going. So welcome to the Inventive webinar series. So I'm going to be kicking off this series and really just to kind of give everybody a bit of an idea. This series is really going to be um, working to share the expertise that a lot of different people within different industries have that would be helpful to startups and small businesses. So my background is I am an intellectual property attorney, so I'm the founder of Miller IP Law. So I thought I would kick this one off with something that's a bit more related to intellectual property. So that would be primarily today with copyrights. And so wanted to kind of go through and share that. Couple things just to note at the beginning of the webinar. So one thing is for everybody that's either is registered for the seminar and or is attending it live, you'll get all of the slideshows afterwards. And so you'll get both a link to this live webinar for your reference later on, as well as the slideshow. And so you're welcome to take notes, but no need to take notes any other than if you're wanting to keep a question aside or jot something down, but at least the materials will be provided to everybody. The next thing or one other thing to note is if you have any questions or comments, this is intended to be pretty live, interactive. Or this platform doesn't allow for directly being live, but what it does allow for is if you have any questions, if you have a comment, if you have anything that you'd like to me to address during the presentation or during the Q&A sessions, you can just put that as a comment on the post. So I'll see those live as you guys are putting those up. So just put a quick comment on there. I'll make sure to keep an eye on those and answer any questions that might come up. So with that, I'm going to go ahead and share my screen a bit and give or kick things off with the webinar. All right. So give me 1 second as we get this set up. All right, so now as you can see, I've got the the screen set up here, and we're going to really talk through a lot of kind of the differences in how you can go about correctly using a copyright, as well as how you can also get yourself into trouble if you don't use a copyright correctly. One of the interesting copyrights that's come out is going to be the one that's with both Mickey Mouse and Winnie the Pooh. So those are a couple copyrights that have now come into the public domain. Now we're going to go through a little bit of copyrights to talk about what is the public domain, what are copyrights. So kind of giving you a bit of a background on background information before we dive right into Mickey Mouse and Winnie the Pooh. So the first thing, as we get started, before we go too far, simple legal disclaimer. This is not a specific legal advice, just for your or not specific to your situation. So while I'm giving some general advice, giving some or hopefully some good information and helpful takeaways, you should always consult an attorney or other expert that is going to give you specific advice for your situation to make the best determination you can. So with that said, if you want to look more at the legal or disclaimer, you're more than welcome to, but otherwise there's a quick run through. So the first thing is what is a copyright? So if you're to look at a copyrights, so let me back up. There are really three areas of intellectual property. We'll hit on one today. One is patents, one is trademarks, one is copyrights. So patents are going to go towards an invention, something that does something that has a functionality. A trademark is going to go towards branding, so name of a company, name of a catchphrase, a logo, those type of things. Copyrights are going to go more towards something that's creative in nature. So if you're to look at, as an example, a writing, so that could be books, artwork, so it could be painting, a photo, a sculpture. It can also be music, it can be movies, but really anything that you look at that is on the creative nature, something that you're creating, that you're putting in some creativity into, generally falls under copyrights. Now, what do copyrights do? Copyrights are really more so that when you get into wanting to create something that has a creative in nature, that has value to it. So maybe you take a photo and it's a great photo and you want to start selling it to others as they want to use it for their business, or you come up with a book and you write the next Harry Potter or Tom Clancy or Lord of the Rings, pick your genre. But as you were to go through that, then the question is if you're going to put in all this time and effort to do write a book, to make a movie, to do a painting or a sculpture, how do you protect that? In other words, once people read the book, especially with the digital age, it's pretty easy to right click on the image, save as, or take a screenshot. Now you've got the image that somebody took the time and effort to take the photo of or to paint or whatnot. The other thing that you'd consider is that you would also be looking at is, it's easy to knock something off with a or with it being digital. So if you're to take a movie as an example, a movie is now very easy to be able to go through. You can simply, if you want to be less scrupulous, you can download it. You can simply go and write or go to the whichever site and be able to grab that, and now you've got the movie. And so copyrights aren't going to stop people from doing that. You're not going to be able to get a copyright and nobody's going to right click. You're not going to get a copyright and nobody's going to illegally download a movie or a book or whatever, but it does give you recourse. So now if somebody comes along and you put in all this time and effort, now you can say, okay, what is my recourse? How am I going to go about stopping people from leveraging and monetizing what I've put in the time and effort to create now with the copyright. So kind of now jumping into a bit of a few issues when you now look at whether or not Mickey Mouse, Winnie the Pooh, or anything else is in the public domain. Copyrights have evolved over the years as far as the length and the ability to get a copyright. In large part, it's due to Disney. Disney was one that has been pushing for ever wanting to extend copyrights longer and longer. So when you look at why is there differences in copyrights, how long they've been around, and whether or not you can use them, unfortunately you have to look at when the copyright or when the material was actually published. So if you're to take anything really before 1923, no matter what it is, it's going to be in the public domain. Really, even with all the extensions, with all the caveats that the law has provided, anything that's in 1923 or before, you're pretty safe to use. When you get into anything between 1923 and 1963, then you have to look at the date of publication. And as long as the copyright owner has renewed it, they now have 95 years. So if they did it in 1962, they have 95 years from the date of 1962. So that's not in public domain. Similarly, there is also from 1964, so you get into even more complicated, to 1977. Now it's just simply 95 years. You don't have to renew the copyright. It automatically renews and is otherwise in place. So 1923 to 1963, you're going to have to, if they get 95 years, but the copyright owner has to renew it. 1964 to 1977, now you've got a copyright is all automatically 95 years. If you're able to now fast forward to anything that's unpublished, so let's say it's an anonymous work, you don't know who the author is, it wasn't really published or put out in the public domain or for the public consumption, and so you don't really know who the author is, how it came about, when it was published. If that is information is not available to the public, they get 70 years from the time that it is otherwise found. So if it was created before 1978, unpublished work, you now have 70 years and then it becomes public domain. The last one that's the easiest one to create or to work through is anything that's created 1978 or after, it gets 70 years plus the life of the author. So author creates it, however long they live, they are now have a copyright for the length of their life and 70 years after that. So basically their descendants, their people that take over their estate, they get 70 years after the author is passes. So With all of that said, if you were to now look and say, okay, that's great. Now, what does public domain actually mean? And then we'll get to what is in the public domain with Disney. Then, public domain is basically where either because people have waived their rights, they've agreed that they don't want copyrights, copyrights expired, whatever the reason is, and you can see a few listed here, is that they have given up their rights to enforce or to stop other people from using their copyrighted material. So it enters in the public domain. Anybody can use it. They can modify it. They can reproduce it. You can use or sell it. You can make money off of it. It's basically everybody has fair game or fair ability to go out and use that similarly in the marketplace. So with that, as you're going to go about doing that, if something's in the public domain, you have clear rights to it. If it's unclear when you go through this and you're not sure whether or not it's in the public domain, you'll want to make sure that it is in the public domain before you start to use it. So now for the much anticipated Disney examples. If you're to look at Disney's been around for a considerable period of time. Disney started out in the 1920s, and they created Steamboat Willie, and that was one of the characters within that short video was Mickey Mouse. Now, Mickey Mouse at that time was just barely coming out, didn't have as much notoriety, didn't have as much built around it. It was just the very beginnings of the Disney empire. So now, as you can see, there is a movie that's coming out that is featuring Mickey Mouse, not affiliated with Disney, nothing to do with Disney, but it does have to do with Mickey Mouse. So now the question is, how are people able to use this movie theater, which has not paying Disney a dime as far as they've disclosed, not doing anything in association with Disney, and this is a horror movie or a slasher movie, and they are now taking that and they are making it into something of their own. They're monetizing it. They're not paying Disney. So how do they get away with that? Well, if you were to look, Disney, if you're to go all the way back to when or something is now pre-1923, it is now expired. It is now in the public domain. So guess what? We're in 1920 or 2004 or sorry, 2024. It is now entered in the public domain because it was made before 1923. That means anybody that takes this image of Mickey Mouse, they can go and they can put it in the public domain, or they can go and sell it on t-shirts. They can go and make plush toys of it. They can go do movies with it. They can take the original movie, the Steamboat Willie, and they can do whatever they want with it. They can modify it, adjust it, update it. Now the question is, does that mean that Mickey Mouse is completely out in the public domain? Does it mean that Mickey Mouse is simply able to, anybody that comes along can use Mickey Mouse however they want? Disney is going to close up shop? Well, not quite. If you were to look now, there are two different images here. You have one that is Mickey Mouse, and this is from Steamboat Willie. This one is in the public domain. Now here's the one that Disney currently is generally using. They are not the exact same. You can look and see the eyes are a bit different. The how the ears are shaped or in location is different. You can see the face is a bit different. The nose is a bit different. So now all of those things are different copyrighted material, meaning that aspects of Mickey Mouse haven't entered the public domain because they were created after 1923 and more recently. So now you get into this area to where you can use the original image in the public domain, but if it's a newer image, you can't now. There are a couple ways that you can go out using images that aren't in the public domain that we'll hit on in just a minute that allow you to use those in a business purpose potentially. But if it's in the public domain, you can use it however you want. If not, then you can't. Just as a reminder for those that are on the live stream, if you do have any questions along the way, you can throw those in the comments on LinkedIn, and I'll see those as we chat through things, and I'll make sure to respond to them. Okay, now with that caveat, back to the webinar. So the other one you can look at, so Mickey Mouse is one. Steamboat Willie, that is now in the public domain. You're already seeing, whether it's slasher or horror movies, you're seeing other plush toys. You've seen it already in apparel, and we're only 1 month into it, and people are already looking to how you can leverage that. Similarly, Winnie the Pooh is also entered the public domain. Came out at a similar time. It is one where Winnie the Pooh, as you can see the original image up here, this is now a public domain image. Again, You can use that. You could take this image, you could sell it on your website, you can monetize it, you can make a movie about it, you can make pictures about it, you could put it on a t-shirt, anything of that nature. And so if you're to see, again, the genre is, it seems like what the movie industry, or at least a portion of it, is taking anything that's a classic kids character that people have grown up with, and now they have turned it into a slasher movie. So as of 2023, that's when Winnie the Pooh became public domain. So a little bit before Mickey Mouse, and they made a slasher movie about it. So now the question is this in the public domain? Could they do it? They did. You can see that they used Winnie the Pooh. They also, in the movie, not that I've seen it, but had Piglet in there. And you could also have Piglet that was part of the movie. Both of those are in the public domain. Now, could you use this image right here of Winnie the Pooh, Tigger, and Piglet? This one you couldn't. This one is a more recent image. This is some of the toys that you have, or that are coming out, that have this look. If you look at the detail that's in Winnie the Pooh and the detail that's here now, you can see there's quite a bit of difference. Eyes are different, ears are a bit different, mouth's different, all of that. Same thing a bit with Piglet. There is now a more pronounced snout. There is difference in how the hands are drawn. There's just a lot more detail. The other thing you'll notice is this one has Tigger in it. This image does not. Tigger has not entered in the public domain. Tigger was one where they came out with Tigger in the Winnie the Pooh series later on in the series. So he wasn't an original character. And because he wasn't in the original copyrighted material for Winnie the Pooh, you can't use his image yet. So interesting fact, when they came out with Winnie the Pooh, the slasher movie, Tigger wasn't in there. Piglet was. Simple reason was they could use Winnie the Pooh, they could use Piglet, they couldn't use Tigger in the movie, and so they left Tigger out. So though Tigger is, I think, coming out within about the next year or so, but you'll see that he'll start to also hit the public domain. So you'll start to see all of these. Now, I use Disney as an example just because they're iconic. Most people know who Mickey Mouse is or Winnie the Pooh is. They've grown up with them. There are other public domain types of materials that you can also generally access. So a lot of times, as an example, if you were to go to websites that have free music, you can integrate free music and you can download it. They label as free as long as it's a reputable site. A lot of times that's because it's older music. They take a classical music that has been around for 100+ years, and now it's in the public domain, and they use that as a basis for what is that free music. So if you were to take, a lot of times, if you were to take the Beethoven, the Bach, a lot of those classical music that is in the public domain, then that's why a lot of times people don't generally have to pay for that type of music that was out there before or now that the copyright's expired. They can simply go take that music and they can package it. There's CDs where you can go buy where they'll take all the classical music that's in the public domain, they'll put it out there, and now you'll have a CD that you can make money off of, that you can monetize, that is that you didn't have to pay anybody the rights for. Now, with that said, what do you do if it's not in the public domain? So let's see, you go back up to here and you say, okay, so by this webinar, this presentation slideshow, did you just simply violate or Disney's copyrights by using this image or using this image? These are both copyrighted images, and I did not ask for permission from Disney directly to do that. So how did I go about getting that? One is that you can license it. So that, in this case, both the newer Mickey the Mouse image as well as the Winnie the Pooh images were both licensed. They were licensed from Adobe as part of an account that I have. And so basically a license is a way that you can go and either directly with the people that own the copyright or through bodies or, through platforms that have the rights or rights deal with that, with the copyright owner, you can go on and you can pay. So if you're to look at Adobe Stock, which is an online platform, there are other ones like Pixel, there are other ones that you can go through, and as long as it's a reasonably reputable site, if you were to go and you were to get a license, you can then have permission to use that image. One thing to note with the license is that with the license, you have to make sure you're using the license correctly. So one of the places that people often get tripped up on with licensing is that they are going to go through and they're going to say, okay, I went to Adobe Stock, I paid for an image, I got the license, and now I can use it. Some of these, as an example, this Mickey the Mouse image, I paid for an editorial license, meaning I can use it in a presentation. I can use it as part of a webinar. I can't go and take this now and generate a plush toy, and sell it just simply because I went on to Adobe Stock and paid for it. So there are a lot of times limitations as to how you can or cannot use a copyrighted work that you have paid a license for. The second thing you can do is, if you don't want to pay for a license, you can purchase a copyright from an individual. Now, thing you want to make sure that you think about as you're purchasing the copyright from the individual, make sure they actually are the copyright holder, meaning that they created the work or they have rights to it and they own it. So if I created it, but I've already sold it once to somebody else and they have the exclusive rights, even though I created it, I can't sell it to you because I no longer own it. So you can't simply go and sell it to a whole bunch of people for the exclusive rights. Other people you may do it is, I may sell it to someone else who then may go out and sell it again. You can resell these just like any other piece of artwork. You can sell it as a movie or a painting or anything else. So you can purchase those copyrighted materials as long as you make sure that you actually have the rights to purchase it from that individual, or that person that's giving to you has the rights to sell it to you. The purchasing, generally you're just going to have a pretty simple agreement. If you're purchasing it outright, that is an assignment agreement. They assign over the rights to you, that you can now own the copyright. The last thing is just create something yourself. If you want to avoid all the issues, if you go and you create something yourself where it is something that you created out of whole cloth, you did the painting, you made the movie, wrote the book, you own it. Now, you can't simply go and copy someone else's, plagiarizing it. But as long as you create it uniquely by yourself without utilizing others, that is something you own. The one other thing to hit on is with copyrights is that there's also trademarks. Mentioned in the beginning, trademarks are for branding. When people oftentimes get in trouble, they say, okay, I can come up here and I can now grab Mickey Mouse and I can go through Mickey Mouse and I can use it however I want, as long as I use Steamboat Willie. That is true, but it doesn't mean that you don't have rights to put Disney on there. Disney is a trademark. Disney owns the brand. They have continued to maintain it, and they are very aggressive about it, as they are certainly within their rights. So when you start to go about doing this, you'll notice on both of these slasher movies, Disney is not mentioned anywhere on that. They don't have it anywhere in there because they don't have permission from Disney to use a Disney name. I'm sure Disney probably wouldn't want to be so associated or tied with them. And so while they can use the word Mickey, because that's in the public domain, they can use Winnie the Pooh, that's in the public domain, they can associate or use anything with Disney. So when you're using copyrighted material, you have to be very careful that you aren't using trademark terms or trademark material alongside of it. So you don't want to you can't use the company's brand that they built. You can't use the term Disney. Trademarks, as long as they're active, those don't expire. So as long as the company's still around, they're still using the trademark, they're still they can still utilize that and enforce it. So make sure you don't run into any trademark issues. The last one that a lot of times comes up is also AI generated images. AI generated images are, one of those that are becoming more and more popular. The image that I used, if I were to go all the way up to the beginning of this presentation, you see in the background, AI generated image. The question is this AI generated image? What was it based on? How did the AI created it? Because AI generally uses other materials. It learns from them. It uses examples. It uses samples in order to create those images. And so when it does that, you don't know what the AI is using. And so is AI using a 90% the same as an image that's already out there? Is it using something that's 95% different, that the AI took thousands of images and combined them together? Without knowing the source of how the AI created that image, you do run the risk that it is or creates a potential for infringing someone else's copyright. If the AI goes and grabs an image that's owned by someone else, that the AI doesn't have, or the platform that provides the AI doesn't have a license to, and they start using those images, going and scraping them off the internet, you are running a great risk of having an issue with not being able to have the copyrights to it and infringing someone else's copyrights. So with that said, wrapping it up, the giveaway. So if there are a people that have questions, if you said, hey, this is great, Or if you say this isn't great, then you can log off, and hopefully it wasn't too long or too in-depth. But if you did enjoy it, or you had questions that raised other things with your business, with a potential business, a business idea, or anything else, there are a few ways that you're more than welcome to reach out to me, Miller at Miller IP Law, for one-on-one. One is we offer free consultations, whether it's for patents, trademarks, copyrights, other business related legal matters. We offer free 15, 20-minute consultations. You can just do that by going to strategymeeting.com. That links right to my calendar. Easy way for you to grab some time on my schedule, rather than trying to go back and forth coordinate. Just go there, grab it. It'll get on my schedule, and we're good to go. Other ways that you can reach out to me, so I'm Devin, is you can call me or text me at 801-829-8446. You can also email me at devin@lawwithmiller.com. And the last one is, if you're more than welcome to stop by the office here. We always love visitors. We are set up to do both remote as well as in office. So if you ever want to come by the office, there's the office address there as well. So with that, opening it up for Q&A. I haven't seen any comments yet that have come through on the posts, and maybe that was either so overwhelming or underwhelming that there aren't any questions. But I will hang out here for a couple minutes. If people have any questions that they want answered, you can again just post it on the comment section for this webinar, and I'll see those pop up and I'll address them. If not, then I'll hang out here for a couple minutes, and then we'll go ahead and wrap up the webinar. Appreciate everybody that's joined, and for all those that have tuned in, hopefully you'll learn something. Last thing before I turn it over to Q&A, we are doing this as a series. So each week we're going to have a different guest hitting on different things. So if you're saying, hey, that was great, but copyrights really aren't my thing, or I don't have any applicability, we are doing a lot of things, everything from having investors on to what investors are looking at. We're going to be having startup incubators. We're going to be having people that are in finance, that we're going to be having people that are in marketing and branding. And so there's going to be a lot of different types of webinars that are coming out with different people that you can now come and tune into, listen, learn a little bit more about, as well as get some expertise for how you expand on your business and improving it, making it better. So with that, I open it up for Q&A. Anybody who wants to throw in a question, happy to answer it. And otherwise, thanks for attending the first webinar in the series of inventive webinars.